You may be sitting or standing in a variety of places around the world. Why are you interested in the common law? Well, in one way, it's because of the first example of globalization, that is, colonialization and imperialization. As the so-called great powers at the time moved out of Europe and conquered different places, they brought their law with them. As Italy, Spain, Germany moved, and France, so did the so-called civil law tradition. As Britain took on colonial possessions, the image was as their soldiers or their settlers moved from the beaches into the land, the common law slipped easily from their shoulders onto the soil. This, I remember, was an image that I grew up with, for I grew up in New Zealand, obviously a colonial encounter where the British came and supposedly James Cook discovered New Zealand, although of course there was a little issue of several 100,000 Maoris living there. New Zealand, at the time that I went to New Zealand, was and particularly where I went, to university, was a rather white experience. I'm termed a Pakeha, a white European descendant. I went to law school in the South Island of New Zealand, in a place called Canterbury. Although there were several hundred of us, it would, in retrospect, be a very white experience. It's not so much now, but the ideology or our thinking about law at that time was a rather docile one. We were a bunch of people, bunch of youngsters, going there to listen to people to tell us what law was about. And what we were told was very much a view by Pakeha. I remember, and indeed in the book Politics of the Common Law, I relate how in my first year at university we received legal system training by a small man in a black gown who, we had been told, had worked in Kenya at the time of the Mau Mau insurgency and had been a public prosecutor and had been responsible in one way or another for the death penalty on many hundred Mau Mau. Now, of course, we assumed that was an act of saving civilization. We had no idea what the Mau Mau insurgency was. We had no idea that in moments like that, what has come to be called states of exception, or more usually called emergency rule or martial law, that the common law created a place outside of its normal rules, a place where instead of, you might say, due process, fairness and justice, pretty much arbitrary decision making by the executive ruled. Instead of, we now think, defending justice, there was judicial executions of more than 1,000 black Africans, and the rounding up and putting them into concentration camps, 70,000 plus. So what that brings to mind is the idea of subject location and subject knowledge. For me, as a white Pakeha New Zealander, the ideologies that I naturally brought to my study of law were, if you like, one-sided. Perhaps, however, the same could also be said for the other colonial subjects, the non-settlers, the native tribesmen or tribespeople or original inhabitants, because, for example, they were often in the course of colonialization treated as second-rate citizens, or in many cases, such as the Maori and such as the Australian Aborigine. Originally, it would be assumed they would die out, and of course their customs, their law, in inverted commas, as the colonialists saw it, would also die out. It was not necessary to give their law equal status. Common law tradition was actually a very effective, or played a very effective role in colonial rule. One of the reasons for that is that its founding on custom enabled the judiciary and other members of colonial administrations to easily give some recognition to the law, the customs of the people, and to balance it with the incoming law from Britain. Now, today, of course, it's post-colonial. So, even if you are living in a place that received its, if you like, common law tradition through the imposition of colonial power, this is long gone. So what then is the status of the common law tradition in your and in my original country, New Zealand? Is it to be seen with pride as, if you like, a procedure, a mechanism through which a common language with many other people around the world is daily worked through and worked in? Or is it to be seen as an historical imposition whose relevancy has faded? Well, let's think. Although in some respects it is indeed an historical legacy from a colonial imposition, its role today is in a globalized world economy in which many of the aspects of the common law tradition, such as the way international commercial law works through custom, such as the way in which contract law internationally often works, makes common law very, very vibrant and very, very important. However, we also have to realize the tensions that the historical legacy gives in each country. And I'm certainly conscious that in many countries there is a tendency to see some of the legacies of that colonial period as such a handicap that the common law, if you like, should almost be thrown out. But let's remember what the common law is in this situation. It is very much not the actual precise principles or the actual precise rules. It is a modality of thinking, a modality in which the role of the judiciary is considered. It is a situation in which principles of due process, fairness, of the search for, if you like, justice in particular institutional settings has always been there and continues. So it would be, in some respects, a mistake to say that simply because we're in the post-colonial, that the common law tradition should be denigrated. However, we have to also remember, or have to also strive, for the fact that in the colonial position, the subject position of the other, the native, may well have been virtually nil. I'm remembering that when I studied law in the University of Canterbury, at that time we gave very little credence to what is called the Treaty of Waitangi, a treaty that was entered into in 1840 between the Maori and the British. Throughout most of the 19th century, the treaty was not taken very seriously. Against the backdrop of wars with the Maori and the assumption perhaps that the Maori would die out, it was a very low, it had very low legal status. After I left New Zealand in the 1980s, there was a renaissance in dealing with the Treaty of Waitangi. It now is regarded as a foundational legal document. It is regarded as a document that, if you like, founds a partnership between the Maori and the Pakeha. It is given a huge status alongside now ideas about human rights, etc. And it is in no way incompatible with the operations of the common law tradition. If I look across the Tasman to Australia, of course, I am thinking of a couple of metaphors about the common law. One is that the common law is like a garden that's not been organized by any one particular system or any one particular group, but it's full of variances, right? And I'm reminded of one oil painting, which is of an English garden, if you like, there in New South Wales from the late 19th century. And it was regarded as a wonderful colonial painting showing, if you like, the progress that had been brought there. I contrast that to a painting by an Australian Aboriginal of recent years, Sally Morgan, and a painting called Her Place, in which instead of these nice colonial buildings and this beautiful garden on the top, she has some buildings, but underneath the circle she has thousands and thousands of bones of the dead Aboriginal. What she's pointing to is a complete contrast in the way one pictures reality. And indeed, when we think of law, law is a method of picturing, law is a method of structuring reality. So she's asking for a recognition of the historical power of colonialism. Well, wherever you are, there will be certain tensions, and in some places, these will be very much lived tensions between, if you like, the role, as in some places, of Islamic law, common law, and